I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half. Like, there's no way that will have 30 days to be able to study and defend myself from the time of this trial. You gave me bogus laws to look up and information, and you were biased.
I would suggest you apply for a lawyer instead of just complaining.
All right, everyone, buckle up, because today we're about to witness one of the most wildly misguided sovereign citizens ever to enter a courtroom. Yes, somehow, even in 2025, these folks are still out there. This guy walks into court acting like he's unlocked the secrets of the legal system. But here's the kicker: he can barely read. His rock-solid argument? That he's not getting a fair trial because he only had 1 hour to study the law, while the prosecutor spent 7 years in law school. Let that sink in for a second. It's like showing up to a marathon without any training and then complaining that everyone else actually practiced. Zero self-awareness. Brace yourselves. This is about to become a masterclass in how not to defend yourself in court. Watch the disaster unfold and feel free to share your thoughts in the comments as it all goes down.
Versus Benjamin Macario Martinez, 237407ST, 226707ST, and 162435FY. Concerning the matters then we were set over from last time, Mr. Downing, in regard to the underlying matters that are left open, has there been any progress?
Your Honor, an offer, I believe, was extended to Mr. Martinez by letter dated June 8th, while he's been incarcerated in the jail. We have not heard what his response is, so I will leave it to Mr. Martinez whether he wishes to enter a plea pursuant to that on the 2 files he has to that offer, or seek an adjournment.
All right, we're also here for sentencing on a number of contempt. So in regard to the 2 open charges, Mr. Martinez, and your proceeding here today in general, are you choosing to proceed without a lawyer here today?
Yes, I am, Your Honor.
So concerning the 2 files that remain open, 6707 and 7407, Ms. Cass apparently sent you another offer after we had court last time. Mr. Martinez, I have no idea what that offer is. The court is not part of any plea bargaining. You have both of these cases here. What is your position in respect to whatever they sent you?
I would like to file a motion to have charges all dismissed due to the Speedy Trial Act. And also, I didn't get, last time we were in court, I expressed to the court that I wasn't able to have reasonable time or an adequate law books. They're old. I only got an hour and a half. I only know some rules for an hour and a half of studying. So out of my freedom of speech and the rules of professional conduct, I'd like to read what my...
This guy can barely read, yet here he is in court, trying to file motions like he's some kind of legal genius. Honestly, if we had to rate his reading level, I'd generously place it somewhere around 6th grade. But the real showstopper is his complaint that he hasn't had enough time to study the law. Really? Does he think the judge is going to put the entire case on hold for a few years so he can get through law school? That's not a defense. That's delusion wrapped in entitlement. Once upon a time, if you didn't know how to do something, you found someone who did. You didn't pitch a tantrum and expect the entire system to revolve around your lack of preparation. The court's already given him options: hire a lawyer, request a public defender, or, if you're actually qualified, represent yourself. Spoiler alert, he's not. What's next? Will he ask for a delay so he can be sworn in as a Supreme Court justice? Let's get back to this legal comedy. What are your thoughts on this guy so far?
For every waste of time and the more money of the people and their state, I would like to say this under the right of free speech, and I would like to invoke on my rights, civil and state laws, to state and file motions and to be treated fairly by judge and prosecution, to uphold all the laws that are to be held in the courts, and so as me representing myself can have a fair chance without having rights infringed upon by any members of the court, and I'm doing so. I'd like to file a motion to have all charges dismissed upon my rights being infringed and violated. Due to these reasons, rights to speedy trial and to have adequate time to with representing myself, and in doing so, these are my civil rights and need to be enforced and protected. Not enough time to study, even after motion, or the judge throughout plea, not able to study in a reasonable time, having defended myself when it was brought to the court's attention and prosecution, if need to. It's all on court record, transcripts and rights of trial by jury, and adequate time to have my own witnesses, which are under the time frame, and the prosecution knowingly didn't explain what or help me, which is repugnant and biased by the court. And for also the court saying and giving false advice, and also for my bond being excessive and also biased in setting bond by stating it's more than fair when I was unable to bond out. And when it was amended, I have reasons why 30 days from the timeline of being able to represent myself is being infringed on. And I'd like to have my trial by jurors, and these are the few offhand as to why. Most of the Speedy Trial Act and also False Pretense Act 774.49, they have to abide by all Supreme Court rules and also rules of professional conduct. Opinion 4, which is federal, asking for help retaining for motion. Prosecutors Rule 3.8, didn't take action or all actions, making sure my rights were protected. And Rules 4.3, if they know the law and what I'm saying, these are US Supreme Court, Michigan rules. And
Is it just me? Or is everyone else also waiting for the judge to hit him with a classic motion denied? Because honestly, that's exactly where this train wreck is headed. He didn't need to read his motion like he was reciting the Gettysburg Address. At this point, I'm pretty sure the judge let him ramble on purely for the entertainment value. Like, why not? Let's all witness this disaster together. It's probably the only reason she didn't shut it down right away. The truth is, judges can toss out frivolous motions without batting an eye. And this one checks every box for legal nonsense. Rule 11 of the Federal Rules of Civil Procedure exists for exactly this reason, to prevent people from clogging up the system with baseless, time-wasting filings. And yes, courts absolutely do issue sanctions for stuff like this. But maybe he's holding out hope that if he keeps talking long enough, the judge will suddenly be struck by his sovereign brilliance and toss the whole case out. Spoiler, that's not going to happen.
Stating that I shouldn't be in jail or in prison for fines when able to prove I was unable to meet the court's obligations. And I was also in jail during the time of the one failure to appear. And I don't think it's very fair that with having to go against people that have 8 years of schooling versus my hour and a half, when I've asked every day to go to the law library and kited, and there's no way that my act to speedy trial, if you need that read, can ever be met. And I got a bunch of federal laws too that if we have to go through all them, why, or I can write them up in a motion to have more reasons for dismissal.
All right, thank you, Mr. Martinez. Mr. Downing, do you wish an opportunity to respond, or do you want an opportunity to do a written response, or where are you at with that?
Your Honor, that's a very rambling, if you want to call it, motion. I don't know how any kind of speedy trial is impacted here, in as much as one of these was just set for trial and the first trial date was today. He also failed to appear on the other one. He's set for sentencing on that. If he's complaining about legal research, he has a right to a court-appointed attorney to assist him in advising him of all that. I do know the record 2 handwritten responses from Mr. Martinez in response to Ms. Cass's offer letter asking to discuss the offer with her. It says nothing in there about speedy trial or anything of that nature. To the extent that he's setting himself up or trying to set himself up for these objections, I don't think there's any basis for it whatsoever. But if the court would like a written response, we would need a transcript of what he has rambled on about here in order to decide what it is exactly he's arguing.
All right, in regard to the matter, we've spent a good hour and a half or more on the record. I think it was last week, maybe the week before. We went through a whole plea colloquy. We got down to the end. The deal had been made. He decided at the last minute then he wanted to have a trial. So we set this matter over to today's date. He didn't want a lawyer then. He doesn't want a lawyer now, yet you want to complain that you don't have access. You're going up against people with 8 years of education. Which is it, Mr. Martinez? You want to represent yourself or you want a lawyer?
I want to represent myself, but I also was given false information by some court officers that I wasn't allowed to have a standby counsel or have advice by a counsel. And I know there's also a federal law that says that I'm able to have third-party advice. So I like I said, I only got out for 2 days, really, the last 2 days. I don't know how I'm supposed to be able to study upon the law, which I stated last time that the law books are and pages are missing out of them. And I showed guards that last night. Like there's no way that will have 30 days to be able to study.
Is this guy actually clueless, or is he just putting on an act? Honestly, I'm starting to think he's faking it, because it's hard to believe someone staring down real jail time could be this unaware. This isn't some pop quiz you forgot to study for. You don't just wing it in court and hope it all works out. His entire defense unravels with one basic fact. He was offered a court-appointed attorney for free. But instead of taking the help, he flooded the court with nonsense, motions, and then complained that he only had an hour to study the law. What did he think this was? An open book exam? He's basically that kid in class who clearly didn't do the homework, but still stood up and tried to freestyle the presentation, hoping no one would notice. Spoiler, we all noticed. So what do you think? Is this a bad performance? Or is he really this deep in denial? Let's jump back in and see how much worse this gets.
And there's a federal law and if you want to see the Speedy Trial Act, I have it right here. I can read it off.
Pretty familiar with that. I've been at it about 35 years now.
Okay.
So in regard to the matter, Mr. Martinez, your motions are denied. In regard to your lack of a speedy trial issue, the following is my finding. One, first off, I'm going to sentence you on all of these failures to appear in contempt of courts. Last week, you had the opportunity. I dismissed and purged 2 of them. If you pled on 2 of them, we got through the whole plea colloquy on that. And oh, you didn't want that either. So then we went through the hearings. And I found you guilty of 4 contempts because you failed to appear 3 times and you haven't paid. We're looking at a 2016 case that you still haven't paid on. So this is my sentence. You want to say anything in respect to your failures to appear sentencing before I impose sentence? Mr. Martinez.
Yes, there's federal laws state and that you cannot imprison somebody for fines being unpaid. And I already told you that I can prove that I wasn't there. You guys know the law. You're supposed to uphold it on both sides. I know that.
Well, I made my findings. You are able to appeal anything you wish.
You gave me bogus
Mr.
information.
Martinez.
You're not supposed to give me legal information. That's not you're not supposed to do that. The only thing you can tell me is I can go by representation or I'm allowed to have an attorney. You gave me bogus laws to look up and information and you were biased. So there's
That's right.
another reason.
Well, Mr. Martinez, your objections are noted for the record and preserved. In regard to the matter on the failure to appear and failure to pay in 162435 FY, I'm imposing 45 days in jail, 23 days of credit on both counts. In respect to 226707 ST, 2 failures to appear, 45 days in jail, credit for 23 days concurrently with the other case. However, at this point in time, Mr. Martinez is 1, serving a sentence, 2, has failed to appear numerous times in this trial previously, including several trial dates that were set timely. And the reason that it's not going to trial, for example, I gave him a timely trial date back on April 29th of 22, and he didn't do us the courtesy of bothering to come to court. So I am finding under the court rules, there is good cause and clear and convincing evidence that's been demonstrated that he's likely to fail to appear for future proceedings, should I give him a PR bond on this case. So for those reasons, I'm leaving the bond in place. We'll set a firm trial date for July 10th. We'll trail the new file along. And if you change your mind about a lawyer in the meantime, Mr. Martinez, you can make the request to the district court clerk. She'll refer it to the Michigan Indigent Defense Commission. They'll decide whether you qualify. In the meantime, the sheriff has the purview of the resources over there. You're entitled to use the jail resources. The sheriff is the one that's going to decide what the time parameters are. I don't have any control over the sheriff. So you can complain. Your record is set. You have made your record. It's all preserved here today. But in respect to the issue, if you really want to have some assistance and get some meaningful legal advice, I would suggest you apply for a lawyer instead of just complaining about it. But that might actually...
Honestly, I think the judge handled this one with a lot of patience. Sure, she could have shut it down earlier, but then we would have missed out on the comedy gold this guy unintentionally delivered. I mean, seriously, what was going through his head? Walking into court like he had the upper hand, stumbling through a crumpled piece of paper that probably came straight off the jail floor. Did he really think he was about to outsmart the system? This is exactly why understanding your rights is important. Not so you can twist the law into some fantasy version of reality, but so you don't end up embarrassing yourself like this. The courtroom isn't a platform for conspiracy theories or DIY legal drama. Judges don't have time for nonsense, and even though this one stayed calm, no court is going to humor baseless motions when you've got a public defender ready to help. For free. Honestly, this was one of the worst arguments I've ever seen. It felt like watching a slow-motion car crash, a perfect example of what not to do in court. The law isn't a choose-your-own-adventure book. You can't skip chapters and invent rules as you go. That said, it did make for some great entertainment. Classic sovereign citizen behavior, and if I had to guess, his reading level? Somewhere between 3rd and 6th grade, if we're being generous. Let me know your thoughts in the comments. And if there's another meltdown or courtroom circus you want me to break down, drop the link below. I post new content daily, so don't forget to like, subscribe, and stay tuned. Thanks for watching and take care.